Hi, I'd like to give you a brief update on some new developments with regard to participant fee disclosure. As you may know, the DOL is looking at their electronic disclosure regulations for all ERISA notices, and they had hoped to complete that review before the deadline for giving out the participant fee disclosure notices as required under the new regulation. It now appears quite likely they aren't going to finish that review, so they recently released some interim guidance in the form of a technical release. It's DOL Technical Release 2011-3. What that technical release allows for, certain information for participant fee disclosure, it is permitted to include that information as part of the participant benefit statement. There are special rules that apply to the furnishing of participant benefit statements that the DOL gave us under Field Assistance Bulletin 0603. And in particular, what's good about that Field Assistance Bulletin is that it allows use of the IRS or DOL standards for electronic delivery and has some special rules for website access. The latest technical release allows the use of those same standards, the FAB 0603 standards, for participant fee disclosure for those items that are permitted to be and are in fact included on the benefit statement. So that's a good thing in the interim. There is, however, a bunch of other information, principally the investment information, that is not covered and cannot be included on the participant benefit statement. For that other information, the plan sponsor or the plan administrator, in order to provide it electronically, either has to follow the current DOL rules, or alternatively there's a transitional rule in this new technical release. But quite candidly, I'm not sure how well it's going to work. What it essentially requires is for the plan administrator, plan sponsor, its designee to request from the participant or beneficiary that they voluntarily give their email address for the purposes of receiving this disclosure. And as part of that request, there is a notice that must be provided, basically apprising them of why you are getting that email address and why, what it's going to be used for, and the fact that it can get paper copies if they want, that type of thing. Ultimately, though, what it means is, in most cases, the email address is going to have an affirmative request, or there's another little special wrinkle to the rule that allows you to use an existing email address if it was not assigned by the employer. If it was assigned by the employer, then there's another little wrinkle. You might still be able to use it if the participant has used that email address within the last 12 months to access the plan in some electronic type of communication. Bottom line is, we're glad we've got some interim help here. It's going to be particularly good with regard to the information available to include in the benefit statement. The other information we're still looking it over. I'm not sure how helpful it will be, but the real answer will come ultimately when the DOL redoes their existing electronic disclosure regs, and that still may be at least a year or two down the road. We'll keep you apprised of future developments.